If you've not already heard, there has been some recent activity in infamous e-celebrity Chris Chan's criminal case. Unfortunately, as the internet tends to do, many people are misunderstanding the nature of the recent activity in that case, surmising that Chris Chan is currently walking free. That's not entirely true. Along those lines, I've prepared this quick video to walk you through the recent developments and to, as best I can, explain what the Virginia Autism Deferral statute actually says. Before I get into analysis, allow me to summarize what's been going on with Chris Chan's case in the last few days. As I mentioned in my previous video, late July was when things were going to kick off for Chris Chan's legal case. It turns out that I was more or less correct, but things are going a bit different than expected. In short, the case has been sealed to the public, and Chris Chan's lawyer has filed a motion for an autism disorder deferral, which seemingly delayed a grand jury hearing. What convolutes things is that a transportation order was issued around the same time. It's unclear what that transportation order actually means. It could mean that Chris Chan has been transferred to a hospital, some sort of group home, or simply that Chris Chan might have been transferred to some other sort of jail facility. In fact, the transfer might not have even occurred yet. No one knows, because, again, the case has been sealed. Some on the internet have put those various activities together and have surmised that Chris Chan is currently walking free, which doesn't exactly seem to be true. After all, if Chris Chan really were released from the streets, the internet would likely find out within minutes, as Chris Chan can hardly stay away from sending random people letters and emails. All the same, rather than spending a lot of time trying to speculate where Chris Chan is, let's talk about what this whole autism deferral thing is, and whether Chris Chan is likely to receive it. Virginia Code Section 19.2-303.6 provides for deferred disposition of criminal cases for persons, quote, with autism or intellectual disabilities, unquote. In short, it's a way to give someone probation for certain crimes if they are intellectually disabled. It's pretty obvious why this statute exists. Lots of autistic people do dumb stuff, and it seems likely that those autistic people end up facing criminal charges for stuff they honestly didn't quite understand. It's a bit of a different principle than the usual insanity defense, which I've mentioned before wouldn't likely apply to Chris Chan, and seems to operate as a useful release valve for providing certain less than mentally normal defendants leniency where they might deserve it. That said, the statute is extremely specific and not an automatic get-out-of-jail-free card for people like Chris Chan. Let's unpack what it actually says. First, the statute begins with a series of exceptions. Quote, in any criminal case except for a violation of Section 18.2-31, an act of violence as defined in Section 19.2-297.1, or any crime for which a deferred disposition is provided by statute, unquote. This basically means that you can't use this law if you've committed aggravated murder or if you routinely commit acts of violence. That doesn't apply to Chris Chan, so let's move on. Second, the statute conditions itself on a, quote, upon a plea of guilty or after a plea of not guilty, and the facts found by the court would justify a finding of guilt, unquote. In other words, the statute only applies if Chris Chan admits to guilt or is likely to be found guilty. As I've stated before, this seems fairly likely, at least based on what little we know. I should note that the fact Chris Chan's lawyer has filed this motion doesn't necessarily mean that Chris Chan has outright admitted guilt. I suspect that the motion is couched in some sort of conditional language, like Chris Chan's willing to concede that there is some sufficient evidence to possibly find guilt if and only if this motion is granted, or something like that. Third, the statute says, quote, the court may, if the defendant has been diagnosed by a psychiatrist or clinical psychologist with 1, an autism spectrum disorder as defined in the most recent edition of the Diagnostic and Statistical Manual of Mental Disorders published by the American Psychiatric Association, or 2, an intellectual disability as defined in Section 37.2-100, unquote. That's a lot of words, so let's break that down. Note preliminarily that this means the court may do this statute. It doesn't have to do any of the things listed in the statute. It has the option, meaning that it could force Chris Chan to face trial, notwithstanding the statute. Also, the statute basically says that Chris Chan has to have been diagnosed by a psychiatrist or clinical psychologist with autism spectrum disorder, or an intellectual disability. I honestly doubt that will be a problem for Chris Chan. Fourth, the statute adds, quote, and the court finds by clear and convincing evidence that the criminal conduct was caused by or had a direct and substantial relationship to the person's disorder or disability, unquote. This is a big requirement, so let's unpack it for a second. This statute only applies in circumstances where the court itself finds clear and convincing evidence that Chris Chan's autism and/or intellectual disabilities caused or had a, quote, direct and substantial relationship to the charges Chris Chan is facing. That is assaulting Barb Chandler in that very disgusting way. This is gonna be tough. Think about it for a second. Is it really fair to say that anyone's autism causes them to commit a heinous crime against their own mother? That argument seems a bit of a stretch. After all, at least as far as I know, there's not exactly a rash of autism-related mom bothering out there. All the same, Christian's lawyer could make a plausible argument here. Remember, there's a fair argument that some of Christian's obsessive fans encourage this behavior. As such, a fair argument could be made that Christian's intellectual disabilities make Christian uniquely vulnerable to committing the charged crimes, especially where there's literally a group of people dedicated to tricking Christian into doing bad things. It probably wouldn't be hard to find an expert to back you up on that point, to be honest. Christian lawyer's seemingly pretty good, and I suspect he wouldn't have a hard time finding a sympathetic psychologist willing to argue that Christian's crime is a result of autism, or something like that. Along those lines, I'd absolutely love to read the motion in this case. It's gotta be a wild thing. Honestly, there's a non-zero possibility that the motion contains some of the stuff from the Quickie and other sources. If I'm Christian's lawyer, one of my best arguments is likely pointing out the decades-long attempts to mess with Christian's life and influence Christian's decision-making. Fifth, the statute says, quote, without entering a judgment of guilt and with the consent of the accused, unquote. Note that this basically means that if Christian qualifies for the statute, Christian would technically be found not guilty, even though Christian would otherwise be found guilty. This is something of a big deal, as it could potentially result in Christian not being added to the sex offender registry. With that being said, it's always a possibility that Christian will nonetheless be added to the registry. I'll touch on that later. Sixth, the statute says, quote, after giving due consideration to the position of the attorney for the Commonwealth and the views of the victim. This means that the statute provides both the attorney for the Commonwealth and Barb Chandler a quote-unquote vote in this whole process. I doubt the attorney for the Commonwealth cares too much about this particular case beyond seeing it resolved fairly. Unfortunately, Christian is probably one of thousands of similar cases in Virginia right now. That said, I do wonder how Barb Chandler, the victim in this case, might opine on the situation. Remember, we don't exactly know how mentally sound she is. Assume, for example, that Barb has been provided some sort of guardian ad litem, or psychological counseling. Even if Barb might not be capable of providing an opinion herself, there's a possibility that those other individuals might be able to speak on her behalf, against Christian being given any form of leniency. Seventh, the statute says, quote, defer further proceedings and place the accused on probation subject to the terms and conditions set by the court. In plain English, this means that the court gets to put Christian on probation on their terms. It could mean a lot of things. It could mean that Christian is added to the sex offender registry despite not being found guilty. It could mean that Christian is banned from the internet. It could mean that Christian is required to be in some sort of mental facility, or the like, at least for some period of time. I suspect a lot of this process will depend on the nature of how Christian is perceived by the court. In other words, the restrictions and requirements will likely hinge on how psychological evaluations have gone, the arguments made by Christian's lawyer, and stuff like that. Keep this in mind because the next part of this law is a doozy. Eighth, and perhaps most importantly, the statute provides, quote, upon violation of a term or condition, the court may enter an adjudication of guilt, or upon fulfillment of the terms and conditions, the court may discharge the person and dismiss the proceedings against him without an adjudication of guilt, unquote. This is a normal and fairly obvious condition of probation, but it's a big deal, and it's likely going to be a problem for Christian. Imagine, if you will, the way Christian's lawyer is going to argue the whole, quote, direct and substantial relationship, unquote, prong of this statute. The lawyer's likely going to have to argue that Christian is easily confused, perhaps easily tricked by the internet, delusional about reality, and stuff like that. As such, even if Christian gets a deferral and a probation, it's highly likely that the terms of Christian's probation will be based on those arguments. For example, it's possible that Christian will be required to attend certain programs, if not basically live in a mental facility, for a period of time, and it might even be banned from the internet for some period of time. Stated differently, if Christian's lawyer is arguing that the internet made Christian assault Barb, then it's pretty likely that Christian is going to be banned from all or portions of the internet for a while. That is gonna be a problem. Christian isn't exactly known for being able to follow simple instructions. It seems unfortunately likely that Christian is going to violate the conditions of their probation, especially if those conditions are something like, quote, don't use social media. In other words, I very much suspect that if Christian gets out on probation, they'll end up back in jail pretty quickly, absent some very strict supervision. Stepping back for a moment, at least in my opinion, this case is probably going about as well as it possibly could, given the situation. It seems that Christian's lawyer recognizes the situation here, and is using the law as best as possible to possibly get Christian some sort of probation, while keeping the scandalous details fairly quiet. It seems like the lawyer is actually trying hard. While it's a bit of a bummer here that the case is sealed, that might honestly be a good thing. A lot of Christian's problems have arguably been encouraged by bad actors on the internet, and a bit of a reprieve from that might be kind of important. That said, I'll try to create a video if any future updates emerge. Thank you very much for watching this video. I look forward to your feedback in the comments.